For this week's lecture, I'm covering pages 397 through 403 in the Law of Armed Conflict. It's 3 court cases, and it covers command responsibility. The first case covered in the pages is the United States versus William L. Cawley, Jr. Lieutenant Cawley led the 1st Platoon of Company C in My Lai 4. Now, you're going to have to bear with me in some of my pronunciations here. I don't speak French or Vietnamese, so some of these may be a little off. At his direction, with his personal involvement, Company C murdered at least 350 South Vietnamese citizens on March 16, 1968. These civilians included women, children, and elderly men. Although Cawley did not have his personal involvement, Company C was also responsible for several horrific sex crimes. Cawley was charged and tried in the United States Court of Military Appeals in 1973. Cawley's defense was that he acted on direct orders from his superior, Captain Medina. Cawley claims that Medina had ordered that everyone be killed in My Lai 4. However, Medina denies that he ever gave out such an order, either in his previous day's briefing or on the day the killings occurred. Unless it can be proven that Medina did not give the order, it must be determined if Cawley was aware the order was unlawful. The acts of a subordinate which are illegal impose no criminal liability unless the order is one in which a man of ordinary sense and understanding would know to be unlawful. So, to determine if a man of ordinary sense and understanding would know that the act was unlawful, you have to look at all the relevant facts. So for this case, we have to look at all the relevant facts on Lieutenant Cawley at the time. And according to our book, these factors include rank, educational background, officer candidate schooling, other training while in the Army, including basic training, his training in Hawaii and Vietnam, his experience on prior operations, whether he had any hostile or friendly contact with the Vietnamese, his age, and any other evidence that may prove or disprove his knowledge of its lawfulness. As stated on our textbook, on page 398, it says, unless you find beyond reasonable doubt that the accused, acting with actual knowledge that the order was unlawful, you must proceed to determine whether, under the circumstances, a man of ordinary sense and understanding would have known the order was unlawful. In the end, the findings of the trial found Cawley guilty. He was convicted by a general court-martial of the premeditated murder of 33 infants, children, women, and old men, as well as the assault with the intent to murder a child of about 2 years. He was sentenced to dismissal from the Army and confinement at hard labor for life. The Court of Military Appeals denied his appeal issues. However, his sentence was reduced to 10 years by the Secretary of the Army. The book says this is something that is completely legal. And having already served a third of his time, he only spent 3 days in an Army stockade before he was put on house arrest, and he served a total of 4.5 months post-conviction in Fort Leavenworth stockade before he was released on parole. Our book says that this is a bit of a fail as far as military justice goes. Alright, so for these next 2 cases, you might have to bear with me. I happen to know a lot about these cases. Last summer, I actually studied in Germany and the Czech Republic, and while I was there, I was studying humanitarian law and what occurred in Nazi Germany. So if I go off on a rant or a tangent, I apologize. So this case is the Attorney General of the Government of Israel versus Adolf Eichmann. Eichmann led the Race and Resettlement Office of the Reich Security Office, which was responsible for the mass extermination of European Jewry and other undesirables. The office was also responsible for the final solution. For those unfamiliar with the final solution, the solution was a decision made by several high-ranking Nazi officials as a way to annihilate the Jewish people. I actually visited the mansion where the final solution was determined, And it was a very interesting experience. And while we were there, the tour guide really filled us in on the situation. And basically what was happening was they were shooting the Jewish population in effort to exterminate them, but the shootings were becoming too expensive and it was taking too long and they were running out of bullets, basically. So they had to come up with a better way to exterminate the population, so they decided to switch to gas. And the final solution was a plan to exterminate the Jews in a cheap and fast manner. It's not a nice thing, but that's what it is. After the war, Eichmann was able to escape to Argentina, and while he was there, he lived with his family and he worked for a water company, but he was kidnapped by Israel in 1960. When he was kidnapped, he was taken back to Israel and put on trial. He was charged with crimes against the Jewish people, crimes against humanity, and war crimes. So, just like the previous case, Eichmann's defense was that he had done everything in accordance with his orders from his superiors. He claimed that his SS training inoculated in him the idea of blind obedience as the supreme virtue, and that he had boundless faith in the judgment of his leadership. Now, if you look at the picture here down to your right, this is actually a picture I took while I was at the mansion where the final solution was determined, and it's an original copy of the final solution, and it just lists some of the high-ranking officers that were a part of the determination. So to start off, this is a picture of the mansion where the final solution was determined, and the entire time I was there, I think the most poignant thing to me was just how beautiful of a place it was and how terrible of a thing that was decided there. And it was just such a contrast, and I'm really glad that they've kept it open because people need to see what occurred there. Now, as far as his defense goes, personal responsibility of a government official for his acts lies in the foundation of the rule of law, which was adopted based on common law. As Gary Solis quotes in the Law of Constitution, 10th edition, chapter 11, the minister or servant of the crown is legally responsible for the act in which he is concerned, and he cannot get rid of his liability by pleading that he acted in obedience to royal orders. Now, supposing that the act done is illegal, he becomes at once liable to criminal or civil proceedings in the court of law. Another piece of law used in this trial by the prosecution was Section 47(2) of the German Military Criminal Code, which was not repealed by the Third Reich, which states that whoever commits an offense against criminal law through following of an order of his superior is punishable as an accomplice to the criminal act if he knew the order was illegal. In this particular case, it was self-evident that the accused knew the extermination of Jews was blatantly unlawful and that these were criminal acts carried out on a huge scale. So to sum it up, in the end, Eichmann was found guilty of crimes against the Jewish people, crimes against humanity, and war crimes. He was hanged by Israel on May 31st, 1962, and I did some extensive research of Eichmann last summer, and if there's anything I can say about Eichmann, it was that he was definitely not sorry for what he did. You can see in the quote here, to sum it all up, I must say that I regret nothing. Eichmann died believing what he had done was totally fine, and he believed he was unjustly found guilty and tried of said crimes. So this trial actually took place in Nuremberg during the Nuremberg military tribunals in 1948. And this picture here is a picture I took last summer of the actual courtroom where this trial took place. It's still an active courtroom, but I was there on Sunday, so luckily there was no court cases, so we actually got to see the courtroom. It's been remodeled a little bit, but it's basically the same room. And I'm not going to try to pronounce the top word there. So this is just the United States versus Ollendorf. Ollendorf was a member of the SS Gruppenführer, and he commanded one of the 4 task forces. That's basically what that word means. One of the mobile task forces to carry out the liquidations in occupied countries. So what were they liquidating? They were liquidating Jewish people and other undesirables. His unit was actually responsible for a single mass murder of 14,000 people in 1941, and most of those 14,000 people were Jewish. Overall, he was charged with a total of 90,000 murders. And I'm sure you're starting to see a pattern here, but just like the 2 previous cases, he used the defense that he was committing these acts under military order, and therefore he acted not on a will of his own. He said that soldiers are responsible for following orders and that they must follow the commands of their superiors, and therefore what he had done was not illegal. So this picture here is actually a miniature version of how the Nuremberg courtroom looked during this trial. And here we're going to see what the prosecution said as far as his defense goes. So as we can see on page 401, the obedience of a soldier is not the obedience of an automaton. And soldiers are not required to fulfill every duty assigned to him. As also seen on page 401, it says, a soldier must not, without incurring unfavorable consequences, refuse to drill, salute, exercise, or even go into battle. But that does not mean that he must fulfill every demand. Obedience relates only to military duty. To plead superior orders, one must show an excusable ignorance of their illegality, as seen on page 402. So, basically, they're boundful only to obey lawful orders. So if they know that an order is unlawful and they willingly follow this order, they are committing an illegal act. But if they follow an order and they're not aware that it's an illegal act, it's not their fault, it's on their superior. So in this case, ignorance of illegality. As I said earlier, to plead superior orders, one must show an excusable ignorance of their illegality. There is no law requiring that a man suffer harm in order to avoid committing a crime which he condemns, but the threat must be real and imminent. So basically that means if somebody's holding a gun to your head and says you have to fulfill these orders even though you know they're illegal, you aren't going to be held liable for making those or following those orders because your life was in direct harm. However, if you didn't feel like you were under direct harm to follow said orders, you shouldn't have followed those orders. Now, there is a test to apply to determine whether the subordinate acted under coercion, i.e. was somebody holding a pistol to your head or something similar, or did he himself approve of the act knowing it was unlawful and choose to do the act anyway? In this case, it's seen in the textbook that he argued that if he hadn't done it, somebody else would have. So his argument was he knew that if he didn't do these acts, murdering people in the liquidations, somebody else would have done it anyway, and he was basically a removable resource, and they could have found somebody else to do it, so he felt he needed to do it, because if he didn't, they would get rid of him and find somebody else to do it. So he might as well do it and protect himself at the same time. So in this case, it was determined that he accepted the criminal order and executed it with malice of his own, meaning he knew it was illegal, but he still chose to do it because he agreed with the order. Now, he said, and other people in the branch that he was in said that they were shocked by the order, but they still chose to do it, which shows that there was no follow-through on their moral responsibility. So they knew it was wrong, but they morally decided to do it anyway, showing that they chose to ignore the moral responsibility not to do so. Also, since they knew it was wrong, they carry an individual guilt, meaning that they are individually each responsible for carrying out the orders since they were aware they were illegal and they chose to do so anyway. So in the end, Ollendorf, along with 13 others in the Nuremberg trials, were convicted and hung.